that in the waiting room. And then we're going to start. Hello, hi, welcome everybody. It's a shame whenever I see so many people in a video conference like this. I would love to know where you are from. So please feel free to write in the chat. We know from the enrollments that there are people from all over the world. So please feel free to introduce yourself briefly in the chat and say where you are from.
I'm happy to say good evening or good afternoon from Mumbai, India. This is our main merchant.
Good afternoon.
And I can see Andrea Hartman, and I can see Christina.
Yes, I'm going to introduce myself in a second. I think we slowly start this webinar. So welcome again from my side. I'm Andrea Hartmann, Pirodo. Please call me Andrea, leave it like this. And I'm from Germany. I'm the managing director of the International Mediator Campus. And I welcome you to our first webinar, which will be like the start of a webinar series that we are planning. We are going to offer 2 free webinars each month on different topics around mediation and ADR. It's about mediation techniques. So we have webinars about communication techniques and mindfulness in mediation, but also about the process of mediation and ADR, such as also an introduction to arbitration or some trends in mediation, which is MedArb, for example. So just to give you a brief introduction to who we are, it is the International Mediator Campus. So our aim and goal is to train mediators from all over the world. We have set up a curriculum of 120 hours of quite profound international certified training with trainers from all over the world. And we have groups that are very, very international. And that is also because of our pricing system. We have put into place fair price system. And that means that all the participants pay according to the purchase power of their countries, which we think is fair, because so we have like participants really from all over the world. The groups are very multi-cultural, and that is apart from learning to become a mediator, which is a really great competence and a very useful instruments for all kind of professions, you build up like this international network. So we really invite you to look into that on our website. It's im-campus.com. We put it in the chat in a minute, but that's enough from my side. And I welcome our trainer, like highly recognized, well-known advocate, arbiter, mediator, senior lecturer, Samir Shah from India. Samir, like you come from India, but you practice all over the world, like in many arbitration institutes and courts, and also mediation all around the world. And you're going to introduce us to the role of lawyers in mediation. I hand it over to you. Thank you everybody for coming, and have a good webinar. It will take around 1 hour. And if you have some questions, please put it in the chat. And I hope, Samir, we will have time in the end to answer this then.
All right. Thank you, Andrea, for that brief introduction. Very good morning, good afternoon, or good evening from wherever you are joining from. This, as Andrea said, this is the first lecture in the series of lectures which is being planned by IM Campus. So a big responsibility has been casted on my head today to give it a good start to this series, and I'm sure I would be able to do that. First of all, I thank you, IM Campus, Andrea and Alexander, for giving me this opportunity to deliver today's first lecture, and on a very interesting and important topic of role of lawyers or counsels in mediation. Now, before I start, I would just make a very little shocking and maybe a very contradictory statement. And that is that lawyers have no roles in mediation. Well, I'm sure many of you would agree or disagree, but this is little contradictory to today's topic, which in fact I have on my own suggested. And why I'm saying this is because of the traditional thought process about the role of lawyers as such. You see, over centuries, lawyers have been viewed to be a person who takes care of a client case before a court of law, wearing a black robe and standing before the judge and arguing the case. That's the traditional picture of a lawyer across the countries. And rightly so, because of the education, even now, which is being continued in the law schools of training or giving the university students about what is law and what is lawyerism. Though now things are changing and for good, and therefore the role of and the responsibility of lawyers are also changing. However, there's still a gap between the understanding, both from the lawyer's thought process as well as the client's thought process. So before I go into the actual role of, whether the lawyers have any role in mediation, and if yes, then what? I think it is for the lawyers first themselves to understand their role and responsibilities as lawyers first, and then we can talk of any other ADR models like arbitration or mediation. And to do this, I think lawyers must come out of this traditional mindset of just being, taking care of their client's case and making arguments before a court of law. I think a person as a lawyer has much more important responsibility on his or her shoulder to not only, take care of the client's case, but also to at least make the client understand what is right and what is wrong in the case. If the client is wrong, I think it is a duty of the lawyer to make this fact understand to the client where the client is wrong and where the client is right. Yeah. So I think that is which to many extent has been lagged over the period of time. I'm not talking, there would be exceptions, no doubt about that. But in general, I'm speaking that this is what the lawyers have to understand, that when the client comes to you, approaches you, you are not only just to, view it partially from the client's perspective. I think as a lawyer, you have to be to that extent impartial to understand the client's case and also the other side case. Yeah. And then advise your client accordingly. I'm not saying that by doing this, you compromise your client's interest. I think you would be in a better position to help your client understand and protect their interest if you are fair enough. And this is where, if you have this kind of a mindset, if you have a mindset of resolving the dispute rather than litigating the issue, then I think you as a lawyer is more suited for mediation. And why mediation? Because we see mediation is generally known as a win-win situation, a win-win process where both parties come together, sit together on the same table, and with the help of a third party neutral, try to resolve the dispute. So what is happening here is nothing so far as law point is concerned. The parties are simply conversing with each other, they are negotiating and trying to come out to a solution to the dispute. Therefore, it is more the case if you view from a traditional perspective or from a very strict definition of mediation as a process, then many of us would think that where is the scope of any role of lawyer, because there is no law involved in mediation, and rightly so to an extent. But it is more so the reason that at many stages, in mediation, a client would be in a better position to be supported by a lawyer to help facilitate that negotiation process or conversation or communication which is happening in mediation. We come to that during the course of my further presentation of what is the role of counsel or lawyer in mediation. So in this background, I think, as I said, the first step is for the lawyers themselves to understand their own role and responsibility as lawyers, and then they can view of making some effort to facilitate mediation. So if we as a lawyer, I also am a lawyer myself first, and then an arbitrator and mediator now, but fortunately I have been given that kind of a mentoring, that kind of education in law school, to view dispute or to view a case in a very different perspective than in a traditional mindset. So I take myself as fortunate to have those seniors and mentors with me who have molded my thinking that way. And that is exactly is what required today. Because you see, we are talking of mediation as an ADR process. ADR, alternate dispute resolution, meaning alternate to the traditional litigation process. So if we are again bringing the same litigation methods or same litigation mindset in ADR, then there is no point in having an ADR at all. So therefore, you need to have a very, very different mindset when you're approaching any ADR process, be it arbitration or mediation or conciliation for that matter. So thus, it is for the lawyers first to understand their own role, their own responsibility towards client, both in litigation as well as in ADR, and then jump in to help a client in mediation or arbitration. Now, having said that, I think let me now start with the current topic of what is the role of a counsel or a lawyer in mediation. You see, ultimately, mediation is a game in the sense of game of communication. It's a back and forth conversation which is happening between two disputant parties in presence of a third party neutral who tries to facilitate them to come together on the same wavelength and to resolve the disputes. That's what in nutshell is happening in mediation. Now, how lawyer comes into picture. Now, lawyer comes into picture because generally when there is a case, be it commercial or any dispute, a party would definitely approach his or her lawyer to take advice what to do in that case. Now, this is where the first role of lawyer starts. So a lawyer role in mediation has three phases. One, before the mediation. Second, during the mediation. And third, after mediation. So there are three distinct phases where a lawyer has his or her role to be played on. So let's talk of the first stage, which is the pre-mediation stage, where a client has come and approached the lawyer about the case. Now here, it is not necessary that there is a mediation process being agreed between the parties. Yeah. So therefore, it is more so the responsibility of the lawyer to make the party or the client aware about the case at hand and what could be the probable procedure or mode of resolving that case. Now, it may happen that a case which is being the client which has come with the case is a type of a case where after reviewing, you as a lawyer think that this is not fit for mediation or this is not fit for ADR. Therefore, you will not advise your client to go for ADR and waste time, energy, and efforts into that. Yeah. Rather, you would suggest a client to go for litigation straight away and decide the dispute. So this is first step where you have to make the client understand. And before making the client understand, you have to make yourself, assess where the case stands, what is the case all about, and what could be the probable solution, which method would be good or bad for solution. Secondly, once you have assessed it yourself that this is the best move, whether ADR or litigation, whatever, assuming that you as a lawyer has come to an assessment or come to a conclusion that mediation is the right process for this case, then you have to make the client understand why mediation or what mediation is all about and why you're suggesting mediation. So this is another important step where you have to make the client understand, because many times the clients are not aware of these ADR approaches. Yeah, because they are coming again, as I said, from the traditional mindset of their view that if there's a case, it has to be resolved in court. So here, I think you as a lawyer has a responsibility of creating that awareness, making the client understand about an ADR processes where arbitration, mediation, or conciliation could be also taken help to resolve the dispute. So again, awareness and making the client understand about mediation or ADR is the next role or next step of a lawyer in ADR process to start with. Thereafter, once you have convinced your client that mediation is the right process, then there is another issue of who would be the mediator, how to select a mediator. That is again, a very important step and equally important role to be played by lawyer to advise the client who could be or who should be a mediator in that particular dispute, depending upon what kind of dispute is there. For example, if it's a commercial dispute, you would suggest a mediator like a business person or maybe a professional, chartered accountant, if there are accounting disputes involved in those commercial disputes, who could better understand the dispute or the issues at hand and be able to facilitate it more effectively, rather than calling someone who has no knowledge or who's new to the whole subject as mediator. For example, in matrimonial disputes, you would need a person who has that experience of handling such dispute, or someone from, let's say, from a psychological background who can understand the psychology of the parties, because in these kind of dispute, there are more emotions involved in that between the parties. So it is better to have that kind of a person to sit as mediator. So likewise, depending upon different cases and the circumstances, you have to advise your client who could be a good mediator to be selected for that matter. I am talking this from a private mediation perspective. If it is an institutional mediation, then yes, the process differs from that, because many institutions would have their own panel mediators, and by rules, it is the institute who would choose or who would appoint a mediator, where therefore your role as such as a lawyer for appointing or selecting mediators is very limited, or is not there at all. But in a private mediation, definitely yes, as a lawyer, it is your duty, your responsibility, and the client would expect this advice from you to select a good, effective mediator for resolving that dispute. So I think for initially, if we just, if I summarize the initial role of lawyer pre-mediation is like this. Many times, it is a process, mostly in the Western countries, may not be that true for countries like India and other places in Asia, but many times it happens, it starts with the lawyer sitting with the other side lawyer to come out with understand issues at hand and to come out with a joint statement, to prepare a joint statement. Yeah, that way it is, I mean, you can better understand each other's perspective, each party's perspective for that matter. Then preparing a negotiation strategy with your client. What are the best possible way out? Till what extent, what are the limitations of your client? What are the weaknesses of the client's case? What are the strong points of client's case? Similarly, you have to view from the other side's perspective also. So this way you prepare a good negotiation strategy initially. I mean, it may change during the process of negotiation, during mediation, but at least you have an initial negotiation strategy with your client, that this is we can go this far or we have to limit ourselves to this extent. Third, it is also important to prepare your client about the opening statement which will be made generally, and it is always advisable that it is a client who should make the opening statement rather than the lawyer. However, if the client is not confident, definitely the duty is cast upon the participating counsel or lawyer to make an opening statement. But it is always advisable that the opening statement should come from the client to give a positive picture, to give a sense of confidence, a sense of neutrality and sense of positivity to the other side. And here the tone, the language used in that opening statement also is very important. You see, like, to say that you're wrong, it may sound offensive to the other side. But if you say that I think that this is not the right way to put the issue, so you are actually trying to neutralize the fact that the other side may be wrong. So by putting the words like may, yeah, you can change the whole perspective, the whole tone and the whole message in a very positive way. So these are the things which you have to, as a lawyer, also sit with the client and prepare it, what would be, in what manner the opening statement would be. And then you also have to discuss about the flow, the process which you have to make your client understand, and then strategize accordingly. So these are basically, in a nutshell, what as a lawyer you have to undergo before you actually start or begin the mediation process. Now this is where, I mean, as a role, as a counsel, it is a very important role, because you have to many times prepare your client to go for mediation where your client is not prepared, because as I said, they may be coming from total lack of awareness about these kind of processes, or they may be coming from that old traditional mindset of litigation. So this is a very important, this is a very critical stage where as a lawyer you have to convince your client and make them understand the potentiality of mediation. Now, having said that, the next step is the role when the mediation actually starts. Now here again, a very important aspect, a very important role is being prescribed on lawyers who are attending mediation, because again what I said earlier, as a lawyer you have to shun your black robe, your black coat, and you have to wear a totally neutral, a totally positive and facilitative gown or cloth to help the mediator and the parties to come to a solution. And this is a very difficult task, as I said, because the lawyers are still having that kind of a traditional mindset. And many times, because of this mindset, we as lawyers tend to, become little argumentative rather than submissive or facilitative. And many times I have seen, when I have been sitting as mediator, because of this traditional approach, I as a mediator being addressed as your lordship or my lord. Now, all this is of course because of the, as I said, the traditional mindset, but it happens. So you have to be careful about all these aspects when you are in mediation, how you are addressing the other side, how you are addressing even the mediator. Because in mediation, actually speaking, you are addressing the other party, not the mediator, which is unlike in a court where you are addressing the judge rather than the other side. So this transition is very, very important, and this will come only from practice and proper trainings. No matter you would be a very good lawyer, but I don't think you could be a good mediation lawyer even if you are a good litigator. Though it will help, does certainly, but as I said, since there is no much of law involved in mediation. Therefore, even good litigation lawyers may fail in mediation as counsel. So therefore, one still need a good amount of training and practice to be a good mediation advocate. And that is where, institutions like IM Campus would play a very big important role for training persons to become good mediators. And also at the same time, also training on having a good advocacy skill. I'm sure they would be coming out with such training programs of, also giving training on enhancing the advocacy skills in mediation, which is also very important apart from just training the mediators themselves. So having said that, once the mediation start, it is an important, again, as I said, it is very important role of a counsel to help the client or the mediator or the whole process as such. If the lawyer feels that it is going in a very different direction, let's say there is an impasse. Now here, again, it is very important, not even from the mediator's perspective, but also from as a counsel to see how to overcome that impasse. Yeah, you may at that point of time suggest, let's say, a small break, or you may suggest a caucus, whatever, just to ensure that this impasse gets over and the process again begins, the negotiation starts on a very positive way. So this is again where you as a lawyer have a very important role throughout, I think, the mediation. At each and every stage, you have to be there. The client expects you to be there to help the client, not only facilitating, but also to ensure that the client's interests are also protected if you feel that the client is trying to compromise or bargain too much against his or her own interests. So here also you have to see that your client's interests are protected to the best of the client's, to the best of the circumstances. At the same time, giving a fair proposition to the other side's interest also. Now, this is very difficult, but of course, it can be, molded through, as I said, practice and of course training. But this is another important aspect, that though the client is expecting you to, present or make a legal submissions, but you have to be very cautious at what point of time you have to put the legal aspect forward and or to take a step backward. So though mediation, as I said, may not involve law to that extent, but yes, to protect the interests of the client, you may have to make legal submissions, which is a right of your client under law. So how you make it, at what stage you make it, and how you mold the whole process is where, as a counsel, is your duty, your responsibility. So this is again a very, very critical stage, a very important role which have to be played by the lawyers, and especially to after shunning your traditional mindset and coming on a totally facilitative way in mediation. Now, having said that, I think there is the third phase is post mediation. Now, what may happen that the mediation may be successful or it may not be successful. If it is successful, definitely your role is again there to help client to come to a settlement agreement. What would be the contents of those agreements, how it is to be worded, how it is to be drafted, all those aspects and all those responsibility is of course upon you as a lawyer. However, if it is not successful, then also you have to now advise your client about the next course of action, or why it was not successful, what went wrong, where now you have to make it set aside or set right, and what are the future course of action. So at each and every step of mediation, before, during, and after, I think a lawyer is a very important part of the whole process, not only for the client, but also for the mediator, to help mediator facilitate the parties to come to a resolution. Yeah. So overall, I think what I started with that totally contradictory statement, I think now many of you would agree that there is definitely a very important role of a lawyer in mediation. Now, there is another important aspect of understanding this role is what are the good quality of a mediating lawyer. Now, according to me, as the main important aspect or main quality of a good mediating lawyer is the mindset itself. As I said in the beginning, if you are having that traditional mindset of litigation, of adversarial process, then you should not take up the responsibility of attending a mediation as a counsel. You have to have that impartial, fair and neutral views or vision or thought process, at the same time balancing it with your own client's interest. If you can do this, if you are so much passionate about it, if you think that you can balance this out, you have that ability of coming out with this balance, then only I think you should take up this responsibility. Because as we went through, immense responsibility, immense importance is casted upon a lawyer in mediation. It is nothing to do, I mean, it's not only to do with the party itself, but it also depends upon how you as a lawyer are supporting the party during that mediation, and how you are as a lawyer are even supporting the mediator during the whole process. So in summarizing this whole presentation, if I can just summarize in few sentences, is like this. I think that this challenge, as I just mentioned about the critical role and important role of counsel, can be overcome if two key areas are addressed, namely the attitude and mindset of lawyers today, and the extent of their involvement in the process of mediation. In remolding the attitude and mindset of lawyers to view mediation is a positive light, the key lies in mediation education. Now, this is a very important aspect which we have to understand. It is the fact that lawyers have never been educated in mediation, nor trained in mediation skills in their law schools. It is recommended that mediation be made at least an optional or a compulsory subject in legal education curriculum for all undergraduate law students before they embark into the world of legal profession. And just for your information, in India, from this new academic year 2021, mediation has been made a compulsory part of the law school curriculum across India. And this is a very, very important step which has been taken by the government. And this is what is required. Education is definitely the first step to change this mindset. Therefore, mediation education for lawyers is truly essential if we wish to make the best of mediation for our society. For the effective practice of mediation, lawyers must bring to function explicitly as mediators. It is strongly thought that if more lawyers are able and willing to serve as mediators, clients and cases which are suitable for mediation will have a better chance of getting access to mediation. In essence, lawyers who has experienced the mediation perspective would be more open to acknowledge the serious difficulties in the current adversarial system. The mediation experience would also encourage the lawyers to think out of the box, to come up with breakthrough thinking solutions in the best interest of the clients. And to conclude, I would say that definitely lawyers have an undeniable role in mediation, though it's not that easy, it's not that simple. On one hand, it is facilitative, it is consultative in nature, and also it is very integral part on the other hand. It is one which creates a non-adversarial climate for disputants in order to reach their win-win solution. And therefore, the personality and philosophy, I'm sorry, of the lawyers involved in a case have far more impact than people realizes. Therefore, it is suggested that please select your teammates. When I'm talking of teammates, your lawyers effectively, because many times it happens that you may need people, or the mediation process as such becomes unsuccessful because of the bad choice of either the mediators or the lawyer. And therefore, it is essential that you choose your lawyer effectively for mediation. Thank you very much.
Thank you so much, Samir, for this lecture about the role of lawyers in a mediation. And I ask the audience, do you have any questions for Samir? I also wrote down some, so maybe I just start because you mention often that it is very important to select the right lawyer to come to the mediation with you. How can you do that? There are so many lawyers out there, and also in my experience from Germany, saying that there's a lot of lawyers who have also a little sign on their door saying, I'm a trained mediator. But actually, my experience is that not everybody who says that he or she has experience in mediation, and not and of course not every lawyer from the start, like from to begin with, and knows about mediation. So how can I select the lawyer?
Well, Andrea, definitely it's a little difficult task from the client's perspective, and many times client can make this mistake of going in bad hands in the selecting a totally wrong lawyer for mediation. However, there are no standard for that, but of course you can do some background cross-checking before you approach a lawyer. Nowadays it is very easy because of the internet age and different platforms. You can have a background check. You can also have that kind of a, or you can come out with your discussion, conclusion post your discussion with the lawyer himself or herself, what way the lawyer is trying to give you the advice or the approach of the lawyer towards the case together. Because you see, let's take an example of a commercial dispute. Mm-hmm. The client would definitely be very much aware of the commercial issues in that dispute. Yeah. So therefore, there the client may not need or may not seek any, or may not be requiring any advice or from the lawyer, but the client would be coming to a lawyer from a perspective of protection of whether he or she is right in demanding what he or she feels is correct, or what they should be, or what he or she is entitled to, from the perspective of law. Now, this is where it all depends upon the client, from to the lawyer, how the lawyer is addressing that issue. You see, if the lawyer is totally going on the law side, yeah, then probably it may not be correct, because as I said, in mediation, if you are proposing a mediation, it is not it's not a one-way street. It is always a two-way street. So therefore, it is a very difficult task from the client perspective, no doubt about it, but it is still manageable. Yes, you run a risk. You may run a risk of making a bad choice and being unsuccessful in the mediation, but you learn from that.
Okay, thank you very much. So I took away that I would kind of challenge also my lawyer and ask some questions about his attitude and feeling about the process of mediation, and see from there if he's kind of agreeing to this process and even support it and think it's a good way to settle my dispute, or if he or she is more reluctant, and then I might want to search for another. Okay, we have... sorry.
All said and done, Andrea. All said and done. Ultimately, it's the parties, it's the client's call. It is a client's decision,
yeah,
whom to take in or not to take in. So it's a difficult task, but yes, you have to go through this process.
Thank you. There are some questions in the chat from Mohit, and he or she asks, do you then believe that mediation doesn't have any parameters or structure, and one can take any approach towards getting the result till no one is determinedly affected?
Well, I think this question might be from coming from the general perceptions about, you know, 2 or 3 different standard types of mediation. But personally speaking, I really don't believe in those set types. Mm-hmm. To me, I would take it as the case comes up or as it flows. I may make a fusion of 2 different types, or I might just go with one type. So I will not advise, if I'm there as a mediator, to be bound by these standard types of mediation, because ultimately the goal is to resolve, to see that the dispute is resolved. Now, how you're going to resolve it, it may happen that, you know, by a, let's say, by approaching a facilitative mode, it may lead to a total impasse. So if you are stuck, or if you are binding yourself with one particular type, it may not lead to a, you know, positive outcome. So to me, I think it is it should all be, I mean, you should be more flexible as a mediator or even as a counsel to adopt a particular approach to the whole mediation process.
And there is another question from Raki Budiraya, and this is: being a mediator, I want to know how to tackle those lawyers who are used to come in mediation proceedings with clients and used to anti-mediation words like nothing is going to be happen in the mediation, etc., etc. Basically, such advocates have mindset of no faith in mediation process or having intuition to lose a client. How can we deal with that from the perspective as a mediator?
Yes, definitely it's a difficult position of a mediator in such situation. But since you are there as a mediator and it is expected of you to control the process, you may take a little direct stand towards such counsel. Yeah. And there's way, I mean, as I said, there's way to say this out, stop that out, or point that out. But if in spite of that you feel that it is not working, then you still have that sort of power, I would say, or a duty. You may go with private caucus with the client itself without the lawyers. Yeah, you can do that. And probably in that, the client would also understand if what is wrong and if there is something wrong with the counsel itself. But yes, I would agree that it's a difficult task from a mediator's perspective, because unlike arbitration or an arbitrator, mediator may not have those you know, freedoms for that matter to be so open and direct. But at some point of time, if you feel that, you know, it is actually going against the whole process because of one person's attitude or action, then I think it is a duty cast upon you as a mediator to be clear and direct and try to control that situation.
There is another question asking, I did mediation module in law, but no real life experience yet. Is my module enough, or do I need further education to be accredited?
You see, as I mentioned about education, there are two parts of it. Education in the sense of not only theory, but also practical. And mediation definitely would need more practical expertise and trainings than theory. Of course, I'm not saying that theory is not important, because theory would make you come with that change of mindset, that thought process. But how you put that changed mindset into practice is where the trainings would be effective. So you need to have a combination of both a good education in law school combined with proper training, practical trainings.
Yeah, and I think
where IM campus can be helpful.
No, I think I can add on that it depends also a little bit of the country you live in and how many hours you need to be accredited. There is a really different rules all over the world, and there is also different accreditation. So you need some are local, and then we have also international accreditation. So yeah, it's worth looking into that a little bit. It's a landscape globally that is very diverse, I would say. There is another question, and that is it advisable to have lawyers present if only one party is represented by a lawyer? Would it have an effect on making one party feel disadvantaged then?
Well, it all depends upon the case. It may not have a standard answer to this, because as I said, let's take an example of a matrimonial dispute, a family dispute for that matter, where I would say that initially, if the parties are coming on their own, there's no need for lawyers to be there, because as I said, there are more emotions involved, more empathy is required rather than law at the initial stages. However, in a reverse situation, as stated in this query, it need not necessarily be viewed in a negative way. It all depends how that other side lawyer, the counsel, is participating in the mediation. Yeah, of course, the mediator should ask or should question the other side if they would be coming out with legal support or not, or they would require legal support or not, or they have any issues of other side being represented with legal counsel and they are not. But all said and done, I think it is a freedom of choice of the parties to bring it with the counsel or not. But if one side is bringing in and the other side is not brought in, it may not every time necessarily mean that there's something wrong. It may turn out that the other side counsel would be much helpful in resolving, fairly with the advice and suggestions. So there is no standard answer that it is always negative or is always positive.
And there is another question from Sir Hamdan. He said, the shift in the mindset from adversarial approach to a non-adversarial approach is a challenge for practicing lawyers. Often when you as a counsel recommend to clients for an amicable solution through mediation, is often cast doubt in the capability of the lawyer who is proposing as such. So there must be an appropriate assessment of the case by the counsel, including the BATNAs and VATNAs, so that the client understands their position before concluding to push through the litigation. What is your view on this, Samir? And maybe, Samir, you could just explain briefly what BATNA and WATNA is that is mentioned in this comment and question, please?
See, as I said, it all starts with the lawyer's own understanding, lawyer's own change of mindset. You see, it is because of this traditional approach what the lawyers have today, the impression of their own role themselves, but that is not the case. If we understand, even in this traditional mindset also, what is the actual role of a lawyer, what is the responsibility of a lawyer when the client approaches you as a lawyer, I think it is not difficult to change your mindset. See, today your client is coming to you for advice, for the protecting best of its interest. Now, how you do that? Not every time it is good to go for litigation. The second aspect of it is that the clients have been given this impression that if you go in mediation, it means you're compromising. Now, this is also a very totally wrong impression which the lawyers themselves give to the client many times. Yeah, mediation is not compromise. Mediation is, I would say, a sort of structured and strategical conversation and art of communication to resolve a dispute in a win-win situation. If you are saying it that I am compromising, it's like if the client feels that it's a compromise, then you have to understand that the other side is also equally compromising. Then only you can arrive at a win-win situation. Otherwise, definitely there will be a win or loss. Yeah. So it is not one-way compromise. If you're so fancied about being compromising mediation, then it is not one-way compromise. The other side is equally compromising in his or her own way. So if you look from that perspective, I think your whole thought process, your whole acceptability to mediation will change for that matter. Coming to the BATNAs and WATNAs, I think these are the strategic or tools to conclude whether to go for mediation or not, and if yes, to what extent you negotiate. As I mentioned about during the mediation, till what extent you have to make your client ready for some compromises, to what extent or what are the limitations which you again deal with your client before you actually go into mediation. And of course, during the mediation also, you work out on this, what are the best solutions depending upon what the other side has come out with. So based on these overall circumstances of case, you assess the risk of whether to go ahead into mediation or not, or to what extent you agree to the other side, what extent your client should be compromising or taking a backseat, or sort of making a compromise on that particular issue. So these are the tools which you adopt during or before also and during the mediation to see that a effective win-win situation comes into play.
Okay, and just to clarify, the word BATNA is the best alternative to a negotiated agreement, and WATNA is the worst alternative to a negotiated agreement, which could be like the fallback positions. And if you know them beforehand, then it's easier to find your personal lines and what the fallback position is if the negotiation isn't successful. There is one comment / question from Bharati. She says, maybe if the lawyer mediator could assist and discuss with the client about option generation, would that be like a good way? I think that is very in the mindset of mediation.
Well, I think, yes, definitely it would be a good way to approach the whole case from a mediation perspective. And this is exactly what I was mentioning about, is when you have the mediation meeting with your client. And that's where I said it is equally important how you assess the case, yourself first, and then you put it before the client, where the client stands. What are the weak points? What are the strong points? And what would the best mode to go for the resolution? So definitely, it has a very important aspect or very important place in mediation. Definitely.
Okay, Samir, can I ask you for kind of short answers to the question, because we have still 13 questions in the chat, and I want to try to go through it. I think please no more questions, although we really appreciate it, but just that we can stay in our time frame. The next question is it really important as a mediator to have a legal background?
No.
That's a very short answer, and I absolutely agree with that. I'm a mediator. I don't have a legal background. There's all kind of possibilities of background profession.
What one needs is definitely the subject matter background and experience rather than law.
Yeah, thank you. Another question. One of the objectives of mediation is to ensure that the solution comes from the parties. How do you ensure that the lawyers do not hijack the process and end up with an agreement that parties may disown in the future?
Well, I can't give a short answer to that, but yes, there is a risk of this kind of situation happening in mediation. And therefore, it is more important for the parties also to understand the process and that is why the selection of lawyer is so important in mediation. Yeah. And I think this is one of the aspects which I had been discussing, especially from the perspective of Singapore Convention, where we are talking about settlement agreement, but at the same time we are also talking of challenges to those settlement agreements. So it's a totally contradictory situation, because if we are saying settlement agreement, then there should not be a challenge and at all, because what is settled, and it is settled by the parties. But yes, this kind of situation definitely can arise, and then the parties have to face it. That's a reality.
And then there is more of a comment that is, so it is a bit difficult for mediator who is an advocate as well.
Yes, definitely yes. It is difficult, but as I said, through training and experience, you can overcome this.
Another question, for the spread and success of mediation, do you think that now it's time to focus more on mediation advocacy skills than developing more mediators?
I would say both simultaneously.
Yeah. That was no, it isn't for the mediators to be a lawyer, but in some matters, it's a comment. No, it is not necessary for the mediator to be a lawyer. Oh, okay, that was a comment to the question before. Sorry, I can't read and speak at the same time. Okay, is there another? Oh no, there is no other question. There was some comments and thanks. So I thought it was questions. Yeah, Samir.
One, Mr. Amin raising his hand and wanted to ask something. Mr. Amin Merchant.
Yes.
Oh,
Hi,
yeah.
Samir. Hi, good evening, Andrea. Guten Abend from Mumbai now. The Guten Tag of afternoon is over. It's Guten Abend. Samir, thank you very much. It was a great pleasure hearing you. So I think, I was wanting to put these few thoughts, and I've been lecturing a few colleges, is that students who are actually doing their law degree are often wanting to do mediators courses. And I explain to them that it's important to practice mediation advocacy for the first 4 or 5 years, gain experience to be a resolution specialist. So your mindset changes. And a lot of lawyers and judges also, with due respect, whom I have seen in the mediation spectrum is there's a lot of adversarial lawyers, and there's a lot of mindset of how a mediation should actually progress, even with due respect to judges who are today mediators. So the young students, the mediation, in my humble opinion, friends, is actually going to be disrupting the legal profession. There will be no more litigation, court litigation, and arbitration. People will look for a quicker resolution and a cheaper resolution in mediation. And hence, youngsters, youth should actually look 4, 5, 6 years of building their brand equity as mediation lawyers or advocacy in mediation. I don't like the word lawyer because it has a lot of legal attachment to it, because it's more of adversarial in terms of, and when somebody says a lawyer, he says he's a fighter. No, so I looked at the situation of becoming a resolution specialist. So that's my contribution to this.
I think you're very right, Mr. Amin, when you said it, and that's what even I mentioned. But when I was talking about the education part, I think two things which should be part of the curriculum, and I hope it should be. And one of the most important aspect of this curriculum should be human psychology. They don't teach at all in any law school. And I think it is not only important from a mediation, advocacy or mediators perspective, but it is also important from a lawyer's perspective, because to see from being lawyers or even mediators or advocates in mediation, we are constantly dealing with humans. Yeah, it is the human relation which are at stake. So it is more important that human psychology should be a very important subject, a prime subject in the law school curriculum. Then only you're going to change that kind of then you're going to have that kind of a different mindset of the people. And secondly, through this education, I think what message should be given, or what message should be being projected, is that, you see, life is so short. Nobody's sure of what is going to happen the next moment. Yeah, then why fight out? Let's resolve and go on with your life. Yeah, so that's where that should be the motto of mediation, rather than going into litigation. And that's what I normally end most of my mediation lectures. One very important quote, that in court you will get law, but in mediation you would get justice. And this is what we have to do. Thank you.
Thank you so much. And I have missed out on one question that I want to answer quickly. And this was, do you affiliate organizations in UK for practical experience if I do your training? I think this direction is more directed to me. And I invite you who wrote the question to us to schedule a call with us. You can do that, a free call with us, if you go to the website, and then we can discuss that, because we have a lot of systems in place in order to ensure also practical experience. The training, we believe that a training is only sufficient if there is a lot of practical experience at the side. So it's a combination of theory and of course practicing, and this is online, and this could be also taken to an offline scenario. So please just contact us and we're going to discuss that further. Okay.
I had one question, if it's possible. Samir, you have lawyers in mediation, and a lot of the time, I as a mediator, I always insist that the lawyers drop the MSA, which is a mediation settlement agreement, and not the mediator himself. There have been a little bit of difference of opinions over here. Most of the people in the Western world, they do have a situation, and even in Singapore, under the Singapore Convention, that the lawyers and the parties have to drop the mediation settlement agreement and not the mediators. Whereas in India, we do have many mediators, and the parties asking, can you please drop this agreement for me? And I have not been too comfortable with the mediator. In fact, in a couple of cases, I refused it also. Can you throw some light? You're more experienced than I am, and you know that you're more experienced. I've actually learned under you, Samir, you know that. So just throw some light on it since we have time. Is it okay, Andrea, if he throws light on this?
Samir, go ahead, of course.
Thank you. Thank you so much.
Your question is very, very important, Mr. Amin. So far as the situation in India is concerned, why this is happening is because majority of the mediators are the retired judges, unfortunately. And therefore, the council and the parties take it a short way out, to approach the mediators for drafting the settlement agreement with the impression that, because they are retired judges, they would do the best, which I think is not the correct approach, because what we know of mediation is an actual party autonomy, a party driven process. Therefore, I will not advise the clients and the counsels as well to leave this important aspect of mediation in the hands of the mediator, because it may happen that the mediator may go wrong, may have a different understanding. So it's better that it is the parties or the counsel who should be drafting the initial draft of the settlement agreement, and they may then, after their own discussion amongst themselves, approach the mediator to finally put a seal or whatever, if it is required, as per the different current practices around, to put a seal on that. Otherwise, I will, personally speaking, will not advise or will not take up this drafting on myself as a mediator. However, there is another aspect of this, and that is that if it may happen that because of this, the whole mediation may go unsuccessful, then you have to, as a mediator, assess this situation. If you feel that this is going to, lead to a total failure of mediation, then I think it's better to take at least the first initial step of saying that this is an initial draft which is for approval and confirmation from the parties. They are free to add, amend, or alter to that, and then only it will be finalized. So that way, at least you are balancing out two things, that you are ensuring that the mediation process becomes successful, and also casting an equal amount of duty and responsibility on the parties also.
Samir, thank you so much. And all the participants also, thank you so much for your questions and that you have attended our first webinar. And I'm very glad, Samir, you said we put some pressure on your shoulder to conduct this webinar. And I'm really happy that you have done this in the way you have done this, very interactive, and answered all these questions really in detail. So thank you once again. And for all the others, we welcome you to our next webinars. Please check on our website. As I said, 2 free webinars per month we're going to offer. And Samir is also a teacher, and I think I haven't mentioned that in the beginning. I should have, a teacher in our mediation training, of course. So have a nice day, evening, afternoon, wherever you come from, and hopefully to see you again in the future. Bye.
Thank you, Andrea. Thank you, Alex. Thank you for that, and thank you all for that patient listening and those interactive questions. Really appreciate.